Hello and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. The year was 2013. The CBI was investigating the coal scam, notoriously called the Coal Gate. The CBI director had to submit an affidavit before the Supreme Court of India, but before that, he allegedly shared it with the then Law Minister, Mr. Ashwini Kumar. Controversy erupted and the Law Minister had to ultimately resign. Why? Because it amounts to political interference with an agency which is considered to be the premier investigation agency of the country, which is the CBI, which is supposed to be, which is meant to be autonomous, which might also mean that the government, then the party in power, might misuse CBI for political purposes. This led to the Supreme Court remarking that CBI is a caged parrot, parroting the words and thoughts of its ruling masters, which is the political executive, which is the party in power at the center. More than a decade later, today, while granting bail to the Delhi Chief Minister, Mr. Kejriwal, Supreme Court reiterated the same, telling the CBI that you have to ensure that you dispel this rumor that CBI is a caged parrot. In this lecture, we will discuss how to get bail in PMLA cases. Is bail an exception or a norm? We will look at some of the important judgments related to getting bail in PMLA cases. But before we do that, I urge you to press the like button, drop in your comments, and subscribe to our channel if you haven't yet. So let's get started and let's look at a statement, a judgment given in the year 1977 by Justice V.R. Krishna Iyer. The case was State of Rajasthan versus Balchand. And Justice Iyer is saying the basic rule may perhaps be put as bail, not jail. That means bail is the norm, jail is the exception. For example, the golden rule of a criminal justice system is you are innocent until proven otherwise. You are innocent until proven guilty. If I'm accused of a crime, for example, murder, for example, terrorism, I will be presumed innocent by the courts. It is for the prosecution to submit evidence and prove beyond any reasonable doubt before the court that I am guilty. That means the golden rule of criminal justice system is you are innocent until proven otherwise. That is why bail is the norm, jail is the exception. Because if I'm accused in a particular case, the police will have to carry out an investigation, charge sheet will be filed, and then this matter will go on a trial. And you would know that the delivery of justice in India is very slow. Immortalized by the statement given by Sunny Deol, Tariq pe Tariq. That is why if the trial is going on, and bail is given to an individual, you're basically supporting the liberty which is enshrined under Article 21 of the Constitution. But Supreme Court said bail is the norm, jail is the exception. That means in exceptional circumstances, jail should be prescribed. And which are these exceptional circumstances? For example, if I'm released on bail, I might tamper with the evidence. If I'm released on bail, I might threaten the witnesses. If I'm released on bail, I may be at flight risk. I might run away from this country. If I'm released on bail, I may be a threat to the society. In these exceptional circumstances, I should be kept in jail. Otherwise, bail is the norm, jail is the exception. But there are some laws where this logic turns upside down, where you are presumed to be guilty, and it is for you to prove that you are innocent. Such a law is a special law called Prevention of Money Laundering Act, where if an accused is arrested under PMLA, it is assumed that you are guilty. You have to now, with evidence, convince the court that you are innocent. That means the burden of proof is on the accused, not on the prosecution. But before we start that, we also need to understand what is money laundering. illicit money converted into a legal money. For example, many years ago in United States, there were individuals who were involved in drug trafficking. And obviously, you will get money in cash, but that is an illicit money because drug trade is illegal. How do you convert that illegal money into legal money? These drug traders would also have their laundry shops where you will go and you want to clean your laundry, do your laundry. And for that, you had to pay these shop owners cash. So if tomorrow the government is asking these shop owners, laundry shops, where are you getting this money from? You may well say that this is from my laundry business. But in reality, the bulk of that money would come from drug trade. So you are laundering the money, converting the illegal money into a legal money, illicit money into clean money, or what is called converting black money into white. That is what we call money laundering. And money laundering impacts the sovereignty of a nation. Money laundering has an impact on the revenue generating capacity and capability of a state. That is why there has to be stringent laws to tackle money laundering. And that is why there is an agency called FATF, which is responsible for ensuring that throughout the world there are strict laws against money laundering. And in response to these directives from FATF, the Indian Parliament enacted a law called Prevention of Money Laundering Act in the year 2002, where the burden of proof is on the accused, where you have to convince the court, if you are an accused, that you are innocent, you are not guilty. But even then, if you look at Section 45 of the Prevention of the Money Laundering Act, the very wording of this section makes it clear that in PMLA cases, jail is the norm, bail is the exception. Why? Look at this statement carefully. No person accused shall be released on bail. That means it makes bail a restriction. There is a restrictive sense to this statement, to this section under PMLA, where we can assume that bail is the exception, jail is the norm, because every person accused under PMLA, if the punishment for that offence is more than 3 years, you should not be released on bail. But even then, if an accused is to be released on bail, for that a twin test is to be performed. And what is that twin test? Listen to me carefully. I am an accused in the PMLA case. Can I be granted bail? No. Why? Because the burden of proof is on me. Because I am an accused, I will not be granted bail, because bail is not the rule, not the norm in PMLA cases. But if I am applying for the bail, the condition is that the judge has to hear the public prosecutor. And if the public prosecutor says, release him on bail, the court will release me on bail. Because the condition under Section 45 is, public prosecutor should be given the opportunity to oppose this bail application. And even after giving the opportunity to the public prosecutor to oppose this bail application, even then the court can grant me bail. But for that, a strict twin test needs to be performed. And what is that twin test? Number one, the court will have to assume, the court has to be satisfied that you are innocent. And number two, the judge will have to be satisfied that you will not commit any offence if you are released on bail. What does that mean? If I am an accused in the PMLA case, can I be granted bail? Yes. But for that, two conditions are to be satisfied. The court should be satisfied that you are innocent. But now listen to me carefully. When do I prove that I am innocent? When I am an accused in a particular case, when the police has carried out the investigation, or the agencies have carried out the investigation, then a charge sheet needs to be filed. Then I will give my arguments before the court. Prosecution will give arguments before the court. And once all these arguments have been completed, Then the court will decide whether you are innocent or guilty. That means at the end of the trial normally, you are able to convince and satisfy the court that you are innocent. But here in PMLA cases, the trial may not have yet begun. That means this case is at a pre-trial stage. The trial has not yet begun. And even before the starting of a trial, how can I convince the judge that I'm innocent? That means there are very difficult grounds on the basis of which the bail is granted in PMLA cases. And test number 2, the judge should be satisfied that if I release you on bail, you are not likely to commit any other offense. But who is that judge who will take upon himself or herself to say that this person accused in PMLA cases will not carry out or commit any other offense? This is like the father of a student comes to me that, sir, my child is not studying properly. I'm going to snatch the smartphone from him. Why? Because he uses the smartphone to watch the Netflix movies, for example, to play PUBG. And I try and convince this father that don't snatch smartphone from him because he might well use this to attend classes on Unacademy app. Or he might use the smartphone to log into YouTube and attend this session. But then the father tells me that you take the guarantee that my child will not watch Netflix or play PUBG. Now, why will I give assurance to the father on behalf of his son that he will not use smartphone to watch PUBG, to play PUBG or to watch Netflix? And similarly, who is that judge who is going to take it upon himself or herself to say that this person accused in PMLA cases, if granted bail, will not commit any other offense? Long story short, this twin test makes it very difficult for an accused to get bail in the PMLA cases. But even then there is an exception. What is the exception? If the accused is under the age of 16, if the accused is a woman, if the accused is sick or infirm, then the court may release such people on bail, even without satisfying the twin test as prescribed under Section 45 of PMLA. And for that, we will discuss the bail that was granted to the BRS politician Ms. K Kavitha in a moment from now. But this is Section 45 of the Prevention of the Money Laundering Act. Is PMLA the only special law which has got these stringent bail provisions? No, there are other special laws as well. For example, the Drugs and Cosmetics Act of 1940, the NDPS Act, the Narcotic Drugs and Psychotropic Substances Act of 1985, and also UAPA, Unlawful Activities Prevention Act, which was enacted by the Parliament in 1967. Matter went to the court. Nikesh Tarachand Shah versus Union of India, 2017. A two-judge bench of the Supreme Court. I think Justice Rohinton Fali Nariman and Justice Sanjay Krishan Kaul presided over this bench. And the challenge was to this stringent bail provision under PMLA. And the Supreme Court said these stringent conditions are unconstitutional. Because such onerous conditions, such difficult conditions of bail in PMLA, this is not reasonable. Why? Article 21 of the Constitution. The state shall not deprive an individual of his right to life and personal liberty, except according to the procedure established by law. In Maneka Gandhi versus Union of India, 1978, Supreme Court said we follow due process of law. That means the law has to be reasonable as well. That means the procedures that are mentioned in the law have to be just, fair, and reasonable. And two judges of the Supreme Court are saying that these onerous conditions of bail, these are not reasonable. As such, this provision is unconstitutional. This stringent bail provision under PMLA is unconstitutional. The year was 2017. And how did the Indian Parliament react? How did the government react? The government brought in the Finance Act. The year was 2018. Normally, Finance Act is part of the budget, which deals with the taxation proposals. But it was in 2018, using this money bill route, because in money bill matters, Rajya Sabha has a very limited role to play. Rajya Sabha cannot reject a money bill. Rajya Sabha cannot amend a money bill. Even if Rajya Sabha does not act on the money bill for 14 days, at the end of the 14-day period, it shall be deemed that this money bill has been passed by both houses of the Indian Parliament. Because the government then lacked majority in the upper house of Indian Parliament, used this money bill route and brought back these stringent bail conditions, onerous bail conditions back into PMLA. This was done when this law was amended through the Finance Act in the year 2018, basically negating the landmark judgment of the court in Nikesh Tarachand case. Then what happened? Even this was challenged. Vijay Madanlal Chaudhary versus Union of India 2022. The Supreme Court said, no, this bail condition is constitutional. Why? Because money laundering is a serious offense. It poses a threat to the unity, integrity, and sovereignty of the nation. It affects the revenue collecting capability and capacity of the government. That is why there has to be stringent bail provision when it comes to PMLA, because the government argued that those who are involved in PMLA cases, these are well-educated people, and they deliberately tweak the implementation of the laws and try to bypass the agencies in India and launder the money. So they pose a threat to us. The government said that this law, special law PMLA, is a response, is a global response to money laundering as well as terror financing. Because this illicit money is also then used to finance the terror. But those who challenged this law, they argued that, my lord, how can you equate terrorism with money laundering? What is the maximum punishment one can get if one is found guilty in PMLA? 7 years. Unless and until you are found guilty in NDPS Act as well, where the punishment is 10 years. But otherwise, the maximum punishment in a PMLA case is 7 years. But what is the maximum punishment in cases of terrorism? Death as well. So how can you equate terrorism with money laundering? That is why if in UAPA there are strict bail conditions, we cannot equate anti-terrorism laws with anti-money laundering laws. But be that as it may, the Supreme Court upheld this amendment and said these stringent, onerous bail conditions are constitutional and valid. But the Supreme Court was asked, was it legal for the government to take the money bill route to amend the PMLA? Because money bill is used only for money matters. But you are using the route of money bill to make amendments, stringent amendments to PMLA. Supreme Court said we will not answer this question. For that, we will set up a 7-judge bench later, which will address this issue, whether such bills can be introduced as money bill. For example, Aadhaar was also introduced as a money bill by the government in the Lok Sabha, allegedly to bypass Rajya Sabha. So this question, whether such a bill could have been introduced as a money bill or not, this is a matter which is pending before the court, for which a 7-judge bench has to be constituted. Last month, the Supreme Court Bar Association President and Rajya Sabha MP, Mr. Kapil Sibal, orally asked the Chief Justice of India, my lord, when are you going to set up a 7-judge bench of the Supreme Court, a constitution bench, to review this money bill question? The Chief Justice said, I will soon set up a bench. But then, before setting up that bench, I may well do a Ganesh Puja with the head of the executive, the Prime Minister, at my residence. Pun unintended. But be that as it may, this was Vijay Madanlal Chaudhary versus Union of India 2022. But then came some of the landmark cases related to bail under PMLA. August 2024, an aide of the Jharkhand Chief Minister was released on bail. He was also accused under PMLA, but he was released on bail. Why? Because the Supreme Court said liberty of an individual is always the rule. And depriving an individual of his liberty has to be an exception. Can you deprive an individual of his liberty? Yes, but through procedure established by law under Article 21. But that procedure has to be just, fair and reasonable. If this Section 45 of the PMLA imposes this strict twin test to grant bail to an accused, that does not mean we will make deprivation the norm, deprivation of liberty the norm, and liberty the exception. The Supreme Court said we can relax Section 45 of PMLA. When? If the accused has spent a considerable period of time in the custody and the trial may not be concluded within the short span. If you're an accused who have spent a considerable amount of time in jail and there is no likelihood, there is no possibility that the trial will be concluded soon, till that time, should we deprive this individual of his liberty? Would that not be violative of Article 21 of the Constitution? Supreme Court said Section 45 will be relaxed. That means this twin test will be relaxed if you have spent considerable amount of time in the jail and there is no likelihood of the trial being concluded within the short span. Which means even in PMLA cases, bail is the norm, jail is the exception. BRS politician Ms. K Kavitha, a woman, she was also an accused in the PMLA case. She is currently an accused in the PMLA case, but she also asked for bail. Why? Because when we discussed Section 45 of PMLA, I told you that there are exceptions. If the accused is less than the age of 16, if the accused is a woman, if the accused is aged, sick or infirm, the court can release such people on bail. Ms. K Kavitha approached the Delhi High Court. My lord, release me on bail because there is an exception for me under PMLA because I am a woman. The court, the Delhi High Court said, bail application dismissed. Why? Because Ms. K Kavitha, you are not a vulnerable woman. You are an educated woman who has been the member of the parliament, who has been an important politician, who has been the member of the legislative council as well. So this exception is for a vulnerable woman. Since you are not a vulnerable woman, we will not grant you bail. The bail application is dismissed. Ms. K Kavitha approached the Supreme Court and Supreme Court castigated the Delhi High Court, saying, does Constitution classify women into vulnerable and less vulnerable? By your logic, you cannot release any woman on bail. You cannot say that an educated woman who is not a housewife, a woman who has been a politician, a woman who is an MLC is not a vulnerable woman. Ms. K Kavitha, you are released on bail. She is still an accused but released on bail. Why? Because bail is the norm. Jail is the exception. Now let's come to the bail for Mr. Arvind Kejriwal, the Delhi Chief Minister. In 2021, the excise policy in Delhi was changed. Mr. Manish Sisodia was the excise minister. What was the objective? The Delhi government says we want to enhance the revenue for the Delhi government when it comes to liquor business. The proposal was that the government will come out of the liquor business and encourage private players to set up more shops so that the user experience of those who consume liquor would be enhanced, because private players would be in a much better position to enhance the user experience. And the government will withdraw from the liquor business and ultimately hand it over to the private players. Then came the allegation that there is corruption in this change in the Delhi excise policy. And there is a South lobby. And this South lobby is led by Ms. K Kavitha. And there are private entities, private companies, private liquor companies who are giving money as kickback, as bribe, to the tune of 100 crore to Aam Aadmi Party so that they tweak this liquor policy. This is what? This is corruption. But this is also then money laundering, because this 100 crore is illicit money. But it was given to Aam Aadmi Party. And Aam Aadmi Party then used this money to contest Goa Legislative Assembly elections. That means laundered this illicit money, converted into white money, legal money. Why? Because it was donated to a political party, and then political party can use this money to campaign for its candidates. This was an allegation. Matter went to the court because ED, the Enforcement Directorate, which is under the Ministry of Finance, under the Department of Revenue, under the Ministry of Finance, ED, carried out the investigation because it is the agency responsible for the implementation of the PMLA law. And ultimately, Mr. Kejriwal and other ministers were also arrested. But specifically, we will focus on Mr. Kejriwal because he is the Delhi Chief Minister. Not just the Delhi Chief Minister, he is also the convener, the head of the Aam Aadmi Party. And in this case, what the ED invoked, something called vicarious liability, where you are held responsible for the acts of others. That means if the beneficiary in this case is the Aam Aadmi Party, Aam Aadmi Party is also an accused, which means then the accounts of the Aam Aadmi Party may get frozen. But since the convener of the Aam Aadmi Party is Mr. Kejriwal, the vicarious liability then means that Mr. Kejriwal is responsible for the acts of others. And the other in this case is the Aam Aadmi Party. He was accused in this case and ultimately arrested. When he was arrested, matter went to the court. He asked for bail. Did not happen. But then just before the Delhi had to vote in the 2024 Lok Sabha elections, the Supreme Court granted conditional bail, interim bail to the Delhi Chief Minister, arguing that one of the most important events is underway in India, 2024 Lok Sabha elections. Mr. Kejriwal is the Chief Minister. Mr. Kejriwal is the leader of a national political party. Mr. Kejriwal is not a threat to the society. Mr. Kejriwal does not have criminal antecedents. He does not have a criminal past. So we are releasing you on interim bail so that you can campaign in the 2024 Lok Sabha elections. Once the elections are over, you will have to surrender, and then he surrendered. But then Enforcement Directorate, then the Supreme Court released Mr. Kejriwal on bail, on a regular bail. But as soon as this happened, prior to that, CBI came into the picture. Why CBI as well as Enforcement Directorate? Because Enforcement Directorate looks into money laundering, looks into where the traces of this laundered money is. But CBI looks into the allegations of corruption by the public officials. So ED was investigating Mr. Kejriwal because there is an allegation of money laundering. CBI now comes into the picture because Mr. Kejriwal, as the Delhi Chief Minister, is alleged to have received 100 crores as bribe. So this is bribery by a public official, which will be investigated by the premier investigation agency of the government, which is the CBI. So when the Supreme Court granted bail to Delhi Chief Minister in a PMLA case investigated by the ED, CBI came into the picture and got the custody of Mr. Kejriwal. But in today's judgment, the Supreme Court has said that this CBI investigation was meant to frustrate Mr. Kejriwal, because he was already released in bail under the PMLA case, and to ensure that this person remains in custody, the CBI came into the picture. And that is where the Supreme Court reiterated and repeated those remarks that CBI will have to dispel that you are a caged parrot. That is something that we had to discuss today related to various important Supreme Court judgments on bail in PMLA cases. If you like this video, do not forget to press the like button and drop in your comments and subscribe to our channel if you haven't yet. Thank you for watching. Bye-bye.